So that's changed now. Perfect.
Lovely.
Great. So good morning, everyone. I think it's not every day that you really enjoy the company of so many lawyers together, actually. So I am really outnumbered just not to be among lawyers at this point in time. But yes, having that kind of a legal insight and support is always a luxury in life. So good morning for everyone. We are today going to discuss environmental law, a law which mostly people talk about, but I don't think so that too many people are really aware of what environmental law normally talks about, especially in terms of ESG. Just for everybody, for the starters, which simply say ESG is the environmental, social, and governance piece, sustainability piece that every organization is trying to implement right now, not just for the present, for the future of the world. And it is now becoming an important practice to contribute to the environmental benefits and ensure that there are right social and governance practice. So we have in-house lawyer, Mr. Rajeev Talwar, who's always been guiding us, and this session has been driven by him. I mean, congratulations to the whole team that we are on a 6th podcast now today on going through the multiple topics now. We are with Sanjeev today and Divij. So Sanjeev has been a big mediation expert. I know him right from, I think, the IBC days that he'd been really working a lot with the companies not really been going down under, and he's been helping and supporting them a lot of arbitration and mediation. Environment is going to be a big piece, and I really see he's created institutions around conflict management, which is not really generally a practice that people really see. So not just a practice, I think he's been, with his years of experience, he's been able to build, institutionalize the conflict management process piece and the arbitration expertise that he's built. Along with us is Divij also. Divij is lawyer by profession. We've seen him working in really large projects. I don't know whether we should be able to take names for those corporates or not. I think Divij will be able to allow us to do that when we talk further. But large arbitration, large cases closures, and working on, and he's a partner at Indus Law, a large firm in its own self. So here we are today talking environmental law and ESG. So welcoming you all. Thank you very much for joining us Saturday morning. We see the response has been pretty great already. A lot of people are joining in, and the interest on Saturday morning has been amazing. So over to you, Rajeev sir, taking over from here. Thank you. Thanks a lot.
Hi guys, good morning. And
Good morning, Ji. Good morning.
So, a brief introduction on what ESG is all about. I think Mukesh has already given it to you, right? So our discussion today is basically broadly revolving around the base of the ESG, which is the environmental piece, and added to it the social and the governance, which is of course part of it. And how much interplay does it have with the current set of environmental laws in terms of enforcement and business and general public at large, plus other stakeholders in this entire piece. So to start with, I will put my first point to Divij, that there has been a lot of push around ESG now for the past about a year. So and companies which were already non-compliant are also now reporting their non-compliance ahead in time, apart from a few which were already there in compliance mode. So now those data management is going to start. So probably next year onward, March 25 onward, government will have enough material to start looking at those companies which are not compliant, which have said a yes or no. That is one part. And how do you think this interplay would work out as we go along? Apart from, yes, of course, the other stakeholders which I said, which is like the Greenpeace or the NGOs who are also equivalent stakeholders in this non-compliant atmosphere.
So thank you for having me here. To start off with, our trust with environmental law is not something new. to start off with, India was actually one of the first countries to have an amendment in the constitution wherein it would allow the states to protect and improve the environment for safeguarding the public health, the forest, and wildlife, which actually shows, the responsibility started actually at a very early stage itself. Even if we see enactments pre-constitution, pre-independence era, actually, we had laws pertaining to environmental law even pre-independence. For instance, we had the Shore Nuisance Bombay and Colaba Act, wherein in which one company by the name of Oriental Gas Company this was sometime in 1857. They were fined and penalty was imposed upon them, and compensation was given with regard to discharge by that company. So environmental law and penalties and compensation have been there for quite some time. But yes, it is only recently that we have been seeing push on a corporate level. And the way it is because in 90s we had the liberalization, and there subsequently with the liberalization, the economy opened up, there was a boom, a lot of players came in. But then at the same time, we did not have a proper mechanism per se. So I'm sure all of you will remember the Bhopal gas tragedy. It was actually after that, because even prior to that, we had the Stockholm Convention and everything, wherein we did have committees, but because of bureaucracy, these committees were not able to function properly. So it was actually after the Bhopal gas tragedy that the MOEF actually came into play, and things started to get streamlined. Now, MOEF is one part of it. What we are talking about is economic social governance, wherein the companies, the big companies, it started off with actually reporting of 100 companies. Now, I believe in 2026, the requirement has extended to the top 1,000 companies. Now, the requirement is it is required that apart from the business, they also need to take up a more social role, wherein they, apart from the increasing the business, they also give back to not just the society, but even the environment in some way or the other. Correct. Now, something very interesting I would want to share with you is that, even the PSUs, the public sector undertakings, even they are required. They also have the CSR programs as well. And the government, I must say it's commendable that the government is actually giving them themes for the annual usage of these compensations, as in what would be the theme around it. So sometime it would be environment, sometime it would be with regard to investment towards child education and things like that. So yes, we have seen that as time has progressed from 2013 onwards, because CSR came in 2013 in the Companies Act. Earlier it was there, but in 2013 it started to get more formalized, then with the SEBI regulations and everything. So we have seen this coming, and the intent is to be more responsible, especially keeping in mind that India is looking, has given itself timelines that 2030, what would we want to achieve, 2070, where we want to see ourselves. So things like that. So that is where all this comes in, to have a more a power. We are looking to be a superpower, hopefully, in the next 10, 20 years. But a more responsible superpower is what we are looking at. So that is what I would have to say on this.
So Sanjeev, a point that I pick up from the Bhopal gas tragedy, right? And the stakeholders in terms of, as I said, other Greenpeace and local NGOs and worldwide human rights and all those kind of things. So what would probably, God forbid, nothing goes wrong now, right? But small here, there, projects are going on, and a lot of environmental damages are being reported, dams are being created, So development, then the stakeholders, then the tragedy, then the laws. So it's an arena where probably, जिसको हम हिंदी में बोले मिल बैठ के बात हो सकती है, मतलब it's like mediation हो सकती है, or is it that we have to get into a prolonged litigating environment to get a resolution out of it, and maybe probably learn more steps down the line.
Okay, great. So thank you very much again for the invite. Look, anything whenever you ask about mediation, I think we have a role to play in terms of a discussion, right? Because of course, I'll take a step back with your permission, because I think setting the context is very important, and even for the benefit of the participants, let them understand a bit about mediation the way it needs to be understood. Right. I mean, we all, need a law somewhere. We all need a definition. We all Google, and then we read 3 lines and we say, okay, now we understand what is mediation, or any new concept for that matter. So, I mean, again, not more than 2, 3, 4 minutes maybe, but it's going to be very important. So as Missing Bridge, right, as a platform, we see this is no different debate than a typical debate of environment versus development. That is the very root discussion of the premise, because then things emanate from there. On one side, we all understand, yes, we need to take care of the environment, mother nature, right? But just 2 days back, we had I think yesterday, in times of India, that within 5 years they'll control when to ensure that there's rain in the city, or when to stop it. Now, this is something, rather than getting into a debate with the scientists that, why do you scuttle our initiatives? But the whole idea is that, and what we saw in last year in Dubai, when suddenly there were rains along with, thunderstorms and all, and that jurisdiction is not prepared for that. All this while, they never had a drainage system. But then eventually, in spite of the bit of drainage system, at least in the new setup, they are never prepared for this kind of a cloud burst and the thunderstorm. So, but again, coming back to, so this is nothing but the root is environment versus development, number one. But it's important to understand mediation as a concept wholly as well as in parts. And I'm very mindful when I say the concept versus the law. Fortunately or unfortunately, if you ask me as a mediator from heart, I'll say, I don't know whether we required a law, but today we have a law. There is a legislation which says Mediation Act 2023. So the concept is much bigger versus the law. Concept can evolve. Concept is a good practice. Concept is a mindset. But then a law is a static document, is finite, right? It requires interpretation. It requires enforcement. So you can understand that law is just a subset of a concept. That is number one, which we need to understand, because, when I'm sure Divij and me are going to debate on this thing, then the whole debate will be law versus a concept, and the concept is going to be much bigger, right? So that's one. And when I say mediation has to be understood in whole or in parts, and ideally both, what I mean is the myopic version or the myopic definition is it's time effective, it's cost effective, it's confidential, it's voluntary. This is not relevant. This is absolutely very, very myopic way of describing a mediation. But what is more important is the essence of it. I'll quickly say four important points. One is a dialogue first. That is the whole premise of mediation. Second is non-adversarial, right? Equally important. Third is party autonomy, party empowerment. And the fourth is creative and out-of-the-box thinking, so that you are able to find the common ground. Now, that is the essence. This is what mediation is all about. When two people can resolve their disputes, that is nothing but a simple negotiation. When they need assistance from a third party, because we are all emotional, our emotions take over our rationale in terms of the thinking, and we become erratic, and then, we take positions. You need a third party who's a neutral, who's impartial, who normally we call a mediator. He sits and he ensures a negotiation. So assisted negotiation is called mediation. So in my last 3-4 minutes, what I've said is trying to see what is right rather than who's right. And that is the whole premise of mediation, nothing more, nothing less. Any discussion, any debate, if you have a neutral guy who's not vested ideally in the outcome, and we normally say that in the context of a commercial dispute. because you should not be vested in the outcome, because you'll become impartial, you'll be biased. But in cases like these, which are connected to public policy, which are connected to processes in REM, because they are going to affect the society at large. So who's our counterpart? Counterpart is a state which is supposed to take care of the of its citizens. So that means some authority, some state which is at much higher level, at at a sovereign level. That is where, when you have one of that party like this, then this directly affects your public policy as well as proceedings in REM in a way. So can mediation directly be relevant? Okay, maybe there's a challenge, and that's the reason we go deeper, and that's the reason I gave you a different definition. It's about what is right. It's about finding a common ground, and it's trying to strike that elusive balance. If you're able to do it, environment will be taken care of and development will continue. So that is the very basic setting of the context, so that participants as well as us, we know where I come from, and then it kind of moves from there. Now your point was about whether it's the Bhopal tragedy or anything else. Where, so essentially what do we do when we need to apply the law? We need to mitigate the damages, ideally prevent, otherwise mitigate the damages. But if something has happened, you need to compensate someone, and hence you get into quantifying how somebody else is going to be okay in spite of the damage or the hit he or she had. So this is the whole ideology and the mindset, how our minds are conditioned, that if something has gone wrong, we think to an extent it can be taken care through a penalty, through a compensation, through some kind of a deterrent creation or something like that. But that's the way things have evolved. So our simple suggestion is, try and use a preventive strategy, and then if it fails, just in case, then try and see what is the best curative strategy. So having an impartial at all levels is probably the ideal thing, and I kind of conclude there.
See, a very important point comes out of this is the cost.
Yeah.
Which is very important, since we have a lot of precedents already in our pocket, right? And ESG is heavily focused on the infra and the iron and steel, all those heavy duty so-called polluting industries of the world. Mining, open mining, of course, is one of them, right? So, how does that cost interplay play an important part? Divij, first, from the, your standard litigating agreement, you have clients in these industries. So now going forward with ESG now on the head, right? Abhi to tak tha yaar, theek hai, jab hoga to dekh lenge, but now to it is, everything is reported. So probably those costs would be a question mark in their balance sheets, or probably their back of the mind, that look, boss, 100%, of course nobody can comply. That's rule of the law, right? But at least for that 10%, something can be worked out. And my second question to Sanjeev would be, how can that cost element be interplaying in the mediation sector? Probably every agreement now going forward will have a mediation clause, something like an arbitration already there, right? Because industry wise, it is like MNCs are there operating in India, so their seat of power is outside India. So they would like to, do a mediation or probably a litigation outside India, and don't want to, be in the Indian territory. Over to Divij.
It's a very interesting point you make, and just to add on to what Mr. Sanjeev just said. So it's about striking a balance.
Yes.
And when we are looking to strike the balance, the reason why I would say that mediation would be, or should be, actually the first step before even considering litigation, is because a lot of the companies, not just the companies, even individuals, are cost conscious. Second is, all of us are well aware about the time it takes to litigate.
Yes.
By the time the final order comes up, then the challenge, obviously the aggrieved party, be it the private litigant or the government entity, or for that matter, the polluter may be aggrieved. Then there is the appeal and the SLP. And despite our best efforts, we have not been able to reduce the time it takes drastically to conclude a litigation.
Yeah.
Which is why, yes, mediation would come into play. But then again, with mediation, what would be required is, I feel that there has to be a slightly more formal approach, because there are two ways. Because now if you look at the ESG, keeping in mind the guidelines and the mandatory compliances that we have to do, in the event I do not fulfill those criterias, then what I'm looking at is mediating with the authority for the purposes of the penalty or compensation, for the purposes of in the event I have not met that criteria.
Yeah.
But then let us take a scenario wherein, while I have mediated with the authority, they have penalized me, but the ramifications are such of that non-compliance, wherein third parties are being affected. Then in that scenario, can I stop them from bringing it up in the National Green Tribunal? So which is why holistically,
Correct,
it is required that once I mediate, because we do not want a situation wherein the companies say that, all right, today if I may just mediate with the authority, pay my compensation, and it may be a decent compensation as well. I do not want to be litigating with third parties or NGOs, because whatever said and done, they are also affected parties. Now, there was a very interesting case that I had read. This was sometimes in the 1970s. This is much prior to that United Nations Stockholm Conference in 72 that took place. So there was a small town so this is on the point of mediation. So there was a small town in the US which was actually known for one particular industry. The citizens of that town were quite proud of that industry. It had, because of that industry, there was a lot of employment, development of school. Basically, the local infrastructure was all around that particular industry. Now, sometime in the 70s, because of a disaster somewhat similar to what we saw in Bhopal, there was a chemical leakage, which resulted in death of about 450 people approximately, and over 3,000 were injured.
Oh.
Now, in that scenario, when the company immediately rushed to its lawyers, they asked that, what should we do? How do we protect ourselves? Because obviously there were damages, there would be compensation, there would be litigation. The first advice which the lawyers gave was, call everyone and mediate and offer a compensation. Now, sometime in 1970s, they paid a compensation of $18 million. So if you see the inflation, with the inflation, it is far more than what they had. But they said that, if we would not have ourselves gone, because when they went themselves, even the cost of compensation came down, because otherwise what would be added is the litigation costs, the lawyer's cost, the interest over a period of time, the hospital bills, etc. and etc. And what they were looking was something over 150 or even 300 million at that point in time. It could not be quantified.
Yeah.
So mediation, the two benefits that they got for immediately getting into mediation was, number one, they were able to compensate and save their cost. But at the same time, the people who were compensated, they were compensated in such a way that they immediately had money in their hand. They were able to pay for their expenses. The company also undertook to pay their expenses. So for both the parties, the compensation was reasonable. So mediation does definitely have that advantage as well. So as lawyers, while it was good to hear from Mukesh that he was happy to be in the company of lawyers. It's very rarely heard.
Very right.
So what I would say is that do not always think that the lawyers are with the intent of litigating, because we may feel that the money is more. Whatever said and done, why has ADR come in place? All businesses want a speedy disposal of matters. Everybody, not just businesses, individuals, everybody. And mediation, as rightly put by Sanjeev, is a non-adversarial. And the first thing is there, we appoint a neutral person. But what is also required in these cases is somebody who has an expertise on these things. So while subsequently, when we do discuss, I will be talking about the steps that have been taken in India for mediation in environmental law. Though the trend has so far been that once the litigation starts, it is only subsequently that the mediation has been offered. But what today we are discussing is a step wherein mediation is the first step, followed then by litigation, if required. Many times what happens in mediation is that things can be closed. Give it a go. That is what we are discussing today. And that is what needs to change.
You are very right. In one of the cases, I was at the district court. So the first question which the judge asked about was that before I start my proceeding, would you like to get into mediation, to both the parties? It was a commercial dispute. So, so probably that step has started, or some judges probably are looking at, that kind of atmosphere. So, Sanjeev, over to you.
So, let me start with a small critique.
आप वैसे ही खुश हो गए मतलब इतना मीडिएशन पे हमने
नहीं मतलब उसका रीजन क्या है like I'll tell you what we have got so deep into it right as a concept that it has become difficult to give a straight and a direct and a small brief answer, because in mediation the whole premise is flexibility, the premise is creativity, out of the box thinking. So the issues which are brought on the table, right, what we end up treating is much more than that. That's the whole, that's the whole beauty of mediation. Now, in a court, you will probably put up a prayer and there'll be, I need this and whatever. And judge at the best, he's bound by what is being asked. Now, let's understand and take a step back. Half of the time, and let me say not even half, much more than that, what exactly are the parties looking at? Solution. Right? Solution to the problem, solution to the issue they are grappling with. Now, the question to be answered is solution equivalent to justice or the vice versa? Maybe, maybe not. Right? Now, that's very important. I can quickly take you back in, unfortunate COVID times when a lot of people, spoke to us and they said, a typical tenant landlord issues and all that. And it was like, वो rent नहीं दे रहा और वो कह रहा है कि वो मुझसे rent मांग रहा है. Okay, fair enough. Both have a reason. Now, I got thinking that landlord is not wrong, tenant is not wrong, but they both have been wronged. Right? Now, what is the solution? When they seek justice, can there be a justice to the scenario? Because there is a solution which is required, and I said, guys, you need to sit and talk it through. There can be a moratorium, there can be a staggered escalation, right? There can be maintenance, waiver. I mean, there'll be 20 things, because the parties who are grappling with the issues are the parties who are aware what they need. They are aware what they want. So in between the needs and the wants, they'll have to do a give and take, right? And that is where the common ground comes in. And that's where, what we call in negotiation, ZOPA, zone of possible agreement. Now, I said that's the only alternative. But anyway, look, some people agreed. Some said, no, we'll have to go to the court. I'm an institution. I'm a company. This, etc. Great. I mean, can't help it. I did my bit. Eventually, Supreme Court honorable judge puts up a statement that tenant-landlord disputes need to be settled through a dialogue. That came in the paper as a headline. It's not about making any other statement. It's about there is a limitation. So when a solution is required and the parties know what do they want and what can they give up, right? A third party, irrespective of the expertise or the exposure, they'll have a limitation. So it's not always taking an apple and using a knife and cutting it to half and saying, okay, both of you should be happy. No. The examples we as mediators give is somebody needs the flesh and somebody needs the peel. Because one child wanted the peel for a project. Other one was hungry. It wanted the flesh to eat and quench his hunger. Now see the difference once you speak, once you interact. You figure out who wants what. So what is right probably takes precedence on who's right. That's number one. Second thing is lip service should be avoided, because what happens is, I mean, that's where I started. Flavor of the season. Mediation is there as an act. We have a Singapore convention. Everyone speaks. It looks good. Whoever says mediation, non-adversarial, he's a good guy, right? But it has to move beyond lip service. And that is where we are really, making people aware on the ground in terms of awareness and advocacy, that please understand mediation is a process. The parties decide. The impartial, the neutral, the mediator who's sitting and assisting is not the guy. Yes, he's a facilitator. He can give you a gentle nudge here and a gentle nudge there, maybe in a joint meeting, maybe in one-to-one meetings, right? That's a typical process. But he may not be even an expert, because it's the parties who have to take a call. I mean, we go to an extent that even if a doctor is supposed to be a mediator, right, and he's settling a dispute between two doctors, he'll be biased, because he'll by default he'll try. I mean, over the period he'll start aligning with one approach versus the another. So what is more important in mediation is the process more than the subject. But anyway, I mean, we have a lot to discuss, but I mean, for now, I want to stop here.
So, while you were talking, I was just thinking about one another point. Now, with there was a time before the ESG reports were published. Any infra company getting into some project would call their attorneys over to the office. Look into the act and tell us where we falter or probably might falter. So that angle was probably covered at one time. Now, with the report being published, that would be laid bare, right? So, if that is the point, then probably the new era would be, the attorneys also on the same table, and probably the mediators too on the same table.
Exactly.
Right. So that before the company jumps into, for example, these bids which are open for lithium ion mines in J&K, right? That's a beautiful valley. So probably the ecological damage would be much higher than probably a act to come out with, or a mediator to tell you. So there will be many more stakeholders in terms of Greenpeace or any other NGO who might want to put their hands into it, right? So wahan pe, there is, as per my understanding, there could be an edge in the attorney side, that if these people don't come on the table, then there is a law mandated to it. There is a warrant issued or a summon issued for them to appear. That is one part. Probably on the mediation side, there would not be a provision like that you could, by force of law, call somebody over the table. You may say, okay, boss, I don't want to join, right? A is biased, or B is biased, or C is biased, whatever it may be. What do you think, Divij? Divij, you are on mute, I guess.
Yes, sorry. So it's an interesting point that you make, that how do we, in essence, decide who will be that third party who will mediate between the adversarial parties? Let's put it like that.
Yeah. See, because ministry will stand its own place, industry will stand its own place, the law will stand at its own place. Of course, the larger picture of protecting the climate would stand at its own place. So there are so many stakeholders around a small little 3-word called ESG. But when we expand it out, there are a hell lot of people involved in that.
Correct. So one thing that is different in a mediation, in a mediation and a commercial mediation vis-a-vis the environment-related mediation, is there is a larger group of stakeholders. One is, that is something that we have to consider, because one is the person who is penalizing. Second is the person who is being penalized. And third, which may be a larger group, will be either an individual or an NGO or a group of people who feel that there has to be a restoration along with compensation. Now, such mediations where there is a large group of people, especially when, let's say, there are individuals, a group of individuals who are involved, or for that matter, environmentalists as well, who are, gunning for a restoration,
Yeah.
then they would be more in the sense of a higher penalty and or a stoppage on the project.
Yes.
And while their demand may be justified, as you gave the example of the lithium mines in J&K, a beautiful valley that may be destroyed that way, that would be the extreme extreme argument that they may make, and that would have to be balanced with the requirement for the mining which needs to be done, and how would you compensate or do a restoration, or for that matter, restore at some other place if required. So it would not just be just a neutral person who can mediate. I would still say that there would be a requirement of somebody with some understanding, if not an expert, on this subject, so that
Yes.
he can help. Because what is the role of a mediator today?
Correct.
He is to guide the parties to come at the table and try to resolve that dispute. Now, another advantage of mediation is that because people collaborate, we are not restricted to just that prayer, as rightly put by Sanjeev, as we are not just restricted by that prayer in the petition. There is more that can be put forth, more ideas can be discussed, and the final settlement can be larger than what the prayer in a litigation may offer. Now, when you're discussing this and the people are collaborating, you do require, because many times what happens is that in any dispute, even if it is referred to mediation, the first thing is it is started with an approach that I am right and this is what I want.
Yeah.
So you need somebody balanced who does understand that, all right, you may want this, but this also is something that is the need of the hour. So how do we find that balance? And that is where he acts as the guide with that experience. Now, Delhi High Court, Supreme Court, we are noticing that, there are a lot of senior mediators who are coming, mediating, and they are using their experience, whatever said and done. Another thing interesting is that what we are seeing is, earlier there was a shift from litigation to arbitration.
Right.
Slowly, what we are also seeing is a shift from arbitration to conciliation. The intent is for a quicker disposal, and it has to be cost effective. So mediation, while we may say that it's a myopic view to say that it is cost effective, but I still feel it's an important factor, because not everybody has the budget for those expensive arbitration and litigation.
Yeah.
But I'm not saying that may be used as a pressure tactics to mediate and arrive at a smaller compensation. But at least if you start off with that, both the parties will be in a position to see where they stand and what is the best that they can do in that scenario.
No, in fact, very important, because see, with the environment standing at one side, development standing on the second side, industry standing on the third side, and if we get into a prolonged set of litigation, me is right, you are right, he is wrong. There are project delays, there are development delays, there are cost and manpower pushing, project getting from 100 crores to 500 crores, probably, just for an example's sake. So all those things are there. Very, very rightly said, So probably that advantage of a expert in terms of that relocating factor to compensate for that damage is another point. Sanjeev, what are your thoughts on that? Plus, of course, what we said.
Too many thoughts there. And yes, yes, 2 points which Divij made, and it's more of a, I would say, correction from my side. When I say it's a myopic way of defining mediation, when we only speak about cost and time, right? There's a reason. When we said it's cost effective, everyone started saying it's a pro bono. Everyone started saying mediators should not charge, right? Versus a, say, arbitrator, versus a, a counsel, versus a judge or whatever. So that was taken in a different light altogether. That is where I'm saying cost, by the very fact that you can actually, sit through. It's a voluntary process. And then you can decide when you want to opt out or something. By default, you are containing and controlling cost as well as time. So that was the only point which I made, that it's myopic to only see these two factors. What is relevant is it's futuristic. It can help you preserve relationships and, so much of stuff. So hence the larger essence of mediation as a concept should be seen. That was one. Second thing is with regards to the process versus subject matter expertise. Again, clarification from my side. The very fact, the way you have an arbitrator or, whether it's a soul or a tribunal, and then they can always have an expert, right, who's a subject matter expert. Similarly, in mediation also, there's been a lot of debate. What is more relevant? Subject matter expertise, the example I gave about a doctor, was only to tell you, to give put a perspective that there is a chance of getting biased, because you would end up aligning with something one of the other party, and it's a typical human psyche, where you like someone and probably you won't. So to maintain that neutrality, even if you don't know the subject but you are aware of the process, because at the end, again I repeat, parties have taken a position, they know what they can let go of and what they need minimum. Now, between the play, if you require somebody who needs to have a subject matter expertise, let there be an expert, one option. Then there's an option of co-mediator. You can always have a co-mediator who has more idea about the subject, but the main mediator controls the process, which continues to be the key. That's number one. But I think it's very important. The more we discuss mediation, our entire discussion becomes very restrictive, because today we have an act, though it's not notified in entirety, but there's an act is going to limit the way mediator would be defined, the way a mediation process would be defined, the way a mediated settlement would be enforced, challenged, this, that. So interpretation, jurisdiction, application, everything will be contained because of the law in place. Once you codify something like this, which ideally, even if you ask me today, though we have a law, we would have been happy if it was a good practice, a good etiquette for a society to be instilled, like, morality and ethics and all this stuff. But anyway, since we have a law, let's make most of it. But the reason I'm wanting to, take few steps higher and elevate our discussion, let mediation not be a hurdle when we define any kind of a dispute, the way we are discussing about environment. We need to be talking about conflict management. It's a much larger term. This is important, because the way mediation is being understood, mediator sits in between, you have the disputants on either side, you do your bit, and either it is a success or it's a failure. But a conflict management is much larger issue. You take the problem, you break the problem into parts, every part is treated the way it needs to be treated. Something can be let go of, something needs a dialogue, something needs a mediation, negotiation, something needs a litigation, because adjudication might be required by third party. A law is, need to be implemented. So that is important, which brings us to an important part about the policy, about the rules. It has to be nicely drafted, properly visualized, with enough see-through mechanism, because it's not practical. If it's not enforceable, if it's not feasible for people, unintended consequences would be there. When you allow something to do, right, in the name of development, okay, something, because you are playing with nature, you are playing with environment, you are playing with a subject which is not known fully. Now, there might be unintended consequences. So, you need to have a deterrent for that. But since you can't contain everything, you can't put that and reduce that into a paper on a given day. That means there's a flexibility required. That means any kind of a discussion or a policy making should have a neutral sitting in those meetings as observers primarily. And yes, councils are required, because they need to be on top of the law concern, that this is the law and the rules and the regulations which are applicable. So our agreements, our policies, our rules within the company should be ticking all the boxes. But then there is an impartial whose main job, and I'll call him a conflict manager, whose main job is prevention of a dispute. Because mediation, whenever we are talking, we are assuming there's a dispute and there's a mediator required and we need to resolve a dispute. I'm saying the very fact that the mediator is geared, he's conditioned in a way to think that there is a possibility of dispute here. There is a possibility of dispute there because of a clause poorly drafted, because of inconsistency, because of a dynamic situation we are in, because of exigencies, because of previous experience, because of force majeure. What happens in those scenarios? Do we stop the project? There's a cost, there's uncertainty. You go to a court. Again, we have already discussed, it becomes a trap at times. You need to be at the right place at the right time, but you are working against time at time. So prevention is better than cure. We all understand that. Who prevents it? The people who are vested in the outcome, the people who are commercially involved, they'll have a challenge. Somewhere there has to be a push given by the left side of the brain or the right side of the brain, I don't know, but somebody will say dekh lenge. Now that's a dangerous thing. In spite of your best of the plans, something might still happen. That's what I'm calling unintended consequences. But let there be a guy, maybe suitably, worded, but conflict manager, for the lack of a proper word, maybe observer, neutral, whatever, whose only job is that, guys, whatever kind of agreement, arrangement, or policy you're drafting, there is a flip side to it. He plays a devil's advocate, whether he's an advocate or not, but he does play a devil's advocate and says this can, bring trouble, whether it's from experience or just a good insight or a see-through mechanism or his own earlier exposure somewhere. So that is going to be important, because I just heard Divij saying, sharing with us, in top 1,000 companies need to put in those reports. I also read somewhere it has to be applied all through the value chain and the supply chains and all your subsidiaries and associates and your vendors. And guys, is it practical? You can make a policy, but you are opening a Pandora box. First of all, we are not still clear to contain the boundaries. It's like, in IBC, we are saying compliance of all the applicable laws. Amazing statement to make. Nobody has been able to give me a list of all the applicable laws.
In fact, my next question was on this only to Divij, that the ESG part is enshrined in the Energy Conservation Act, right? Now, I was trying to understand, right now there are no penalty provisions, I think, which have been brought out under that act, right? So tomorrow, how will that work? There is a mining company, so there is a Forest Conservation Act, there is an Energy Conservation Act, there is a plastic waste, there is a water conservation. So will they be tried under those 4, 5, 7, 8 laws, or will they get into a single this thing? Because again, this leads to delays, multiple courts, multiple acts, of course the cost. So again, the next in line is, where will mediation work in that?
So it's a very, very interesting example that you've given. And if you may recall, earlier we had that same issue with the labor laws in India. Although we intend to codify it, but I don't think it has still happened that we have one code for the labor laws. And I think the same problem we are going to be facing, but it's a problem. It's a good problem to have. I'm saying that at least we have started off with something. Now, this was something that we had read when we were law students in sociology, that the law evolves as per the requirement.
Yes.
What I'm saying is, it is good to at least have this problem than not to have it at all. So it is good that we have the law. This evolution or these amendments will come as we see the problems. For instance, the best example at present we can see is the IBC. IBC came up in 2016. Now, while we did adopt a lot from the US and from the UK as well, but we have to adopt it keeping in mind our requirements. It may not be that something that worked in a different jurisdiction will work here, because these problems are specific for us. So similarly, we will start with something, we will see what the problems are, and then amendment will be there. We cannot obviously start off with a draft which is so poor that one just wants to give up. It has to be well thought of. But at the same time, it is not possible to foresee all the problems. But I'm still positive. I would say that it's a good problem to have. Start off with something and amend as we see what the problems are and how it can be resolved. And again, which is why when we are looking at amendments or introduction of laws, what is the requirement? What does the legislative require? To put it out in the public domain, wherein people like you, Sanjeev, me, the general public, who have nothing to do with the law also, all of them together with what they feel should be there. And then a course correction is done, or then amendments are done, and then it is brought into place. So that it's a continuous thing that needs to continue to happen. It cannot stop. It will continue with time. It will evolve, and we will get better at it. That is what I'm saying. But media has to be at that forefront.
Yeah, a very interesting point. This brainstorming can also happen under the mediation chapter, where everybody is neutral. So everybody's sitting there and just brainstorming. यार ऐसा होना चाहिए. So A has a point, B has a point, C has a point, D has a point. Sanjeev, what do you think?
First of all, allow me to take again a step back, because it's interesting, because there are many tangents to the discussion we are having. So first of all, rightly said, let's not be in denial. If there is a problem, we need to identify the elephant in the room. Yes, we'll all keep describing it the way we all see it through our limited exposure, but let's not be in denial. It's a serious issue. But the point we made in the very beginning is the elusive balance. The elusive balance, which is important in all these aspects, is the key. So you start with a good policy, but you have the right balance in the policy drafting, because first problem we are normally facing is the interpretation. Every person who reads, okay, with the best of the lawyers, now they have a version of it. Now everything ends up, so I mean, the example Divij you also took and I took about IBC, number of times specific clauses have reached to Supreme Court, right? And then finally they said constitutionally valid. Now, if the law IBC in totality has been held to be constitutionally valid once, twice, why every clause again needs a stamp of approval? Okay,
Correct.
The kind of time which is lost, the kind of energy which is lost, what kind of a projection we are giving about our country and the system and whatever it is to the rest of the world, be it the ease of doing business or whatever. And in the interim, you are confusing all the stakeholders. Okay, because till the time you don't get a stamp of approval, people say it's all sub judice, right? So courts are taking time because of infrastructure issues. And that is where another point which I wanted to make was, let us not push mediation only because courts are under pressure, because of infrastructure or 5 crore cases pending. This is again myopic. If there is a concept which is non-adversarial, which is good, which has inherent advantages, by default, this should be first port of call for you to discuss it out and figure out. It works, it may not work. Who gives a guarantee? A judge doesn't give a guarantee, an arbitrator doesn't give a guarantee. So why expect a guarantee from a mediation, which is otherwise a noble process? That was one point which I wanted to. Other point is, copy only as much from other jurisdictions. Do copy. So the word is copy, get inspired, don't reinvent the wheel, whatever you want to call that. But the point is, copy to the extent required, but make the tweaks which are relevant for the context. So IBC, yes, earlier BIFR regime. So US was, picked it up, and that is what we had. Then we said, no, this is not working. So we, the pendulum switched to the other end, the UK, creditors in control. Okay, now eventually we realize, no, creditors don't know how to run a business. But now we are struggling with the PPIRP, pre-packs. So, a bit of this, a bit of that. Now, the point is, 8 years and still evolving. One school of thought is, guys, it was a serious business. It was a draconian law. The company can be dissolved, which means it can cease to exist, a non-natural person. So maybe a bit more thought would have been given. The other school of thought is, government has been agile. 8 years, 8 amendments in parliament, unthinkable. Okay, so that means they have their ears on the ground. This is justification. Simple point is, don't make the mistakes you've already made earlier. Make new mistakes. We are all evolving. Things will keep happening. And here another point, lip service, when I said in the previous point, Kyoto Protocol connected to environment, okay, protection and all that. And we were told, US was not a signatory to that.
Even till date, it's not.
Okay, right. No, so I'm just giving you a very macro thing. Cut to the action on the ground. You have a new road which is built. In between, there is a tree. Okay, and nobody there takes off the tree because they don't have approval. It takes forever. In the interim, it is a hazard for the motorist, okay, or whatever it is. But point is, no, we don't have approval. Can we all work in tandem? And this is connected to the policy. So the point is, lip service, the reason why I keep saying is, we just need to be practical. Learn from the mistakes. If there was a tree right in the middle and the road had to be expanded, is it rocket science? You've done it hundreds of times across. So why don't have SOP in a place? Okay, why there's not a regular administrative thing? And the last bit is, as a concept, whether we call it a mediation or a conflict management, whatever, as a concept, I can still assure you each and every type of a dispute is mediatable. In other jurisdictions, they have even gone and they're doing restorative and stuff like that. They're using that in criminal also, which is a long shot in Indian context. But civil, commercial, workplace, community, all this is possible, because simple point is, it's like a homeopathic medicine. Either you get a benefit or there is no side effect. बात ही तो करी, शायद कुछ निकला, नहीं निकला तो go back to the next. Now, in civil and commercial, we are saying med-up should be the ideal strategy going forward. But in environment and all, which is serious, and in REM, then it should be med-lit. Because either you talk it out and resolve, or the law should take its own, role, because it's not arbitrable. And when we speak about law, as in Mediation Act, which is yet to be notified, but if you see, it's a great attempt from the government to make it formalized so that more and more people talk about it and all. But the flip side is Schedule 1. The proposed Schedule 1 has a longer list, which includes, as number 6, anything which is at NGT is not mediatable. So I think that is something which we all need to keep in mind. Though I should have started with that particular, caveat, that in spite of the mediation being discussed, these kind of issues won't be subject to mediation, at least as of now. So we've made a representation to the government, income tax, environment, everything should be tried at least. Give us some time. Maybe we come out with a solution, maybe. And if we don't, put a timelines, 3 months, 6 months, whatever, or even less. But let there be a dialogue before you say it's not mediatable at all. So that may not be good, but I'm sure, our interaction with the government says they are testing the waters. And nobody stops them from curtailing or shortening the list or something going forward. So all that is possible. So that was the my 2 bits on the previous discussion.
I beg to differ here in terms of the evolvement of the law, especially in terms of the environment piece. Why I say so is that environment is something which has a much larger ramification than a tax law or a waste law, or probably a company shutdown law, right? Because here the entire development of the country stands on that foot, right? So without thinking the entire piece in totality, and as very rightly said, that supply chain copied from Europe, from the German laws, where anybody dealing with German companies will have to comply the entire supply chain, right? Or probably dealing with Europe, then you have to have a CBAM involved in that. So probably instead of having so many acts together and increasing the timeline, decision making, as of course the courts are clogged with so many other things, right? So probably even NGT has a backlog on that. I don't know, right? So my point differs there, that it should have been thought of a little more better, because if you look at the energy conservation law, it's more about setting the context in terms of the ESG, the net zero timeline, finished. That's all, right? What about non-compliance? What about penalty provisions? What about probably mediation, arbitration? So many things are there, So that's my point on that.
Two points only. Prevention is better than cure. Hence, even while creating a policy and trying to make it as practical as possible. So on one side, being firm on what you want, but on the other side, leaving that flexibility, because when the law changes, law will always succeed the changes. Law is not preempting the changes, on the ground, because what happens, you have an amendment in income tax. What does a chartered accountant do? They find new loopholes, and then whether we call it a tax planning or whatever it might be. But when something else changes, then you try and figure out what is the way out, So simple point is, even if at a point in time, and that's where I keep saying, law is going to be a document, a static document at the end, and a finite document. Only as much it will be contained, because for a law, you have to go to parliament. Okay, that takes time. They also need to understand what's happening, and they can't sit every day. It's not a dynamic changes in the law, which means the policy itself should be flexible enough, maybe through regulations, maybe through the regulator, that suiting the need or looking at the context, few amendments are possible. On one side, it's firm enough, working as a deterrent. On the other hand, it's flexible enough not to put hurdles, because otherwise what will happen is, a private sector entity at the end needs to be looking at a commercially viable project. That's what the essence is. A government company can do whatever, I mean, that's half of the reason why inefficiency and, the red tapeism and all. So if we are struggling with that, and if we want to invite the private sector, they need clarity, they need certainty, they need finality. But they also need to work in a framework given by the top authorities.
So sorry to interrupt you. The discussion is getting into a very, very interesting mode again and again. So I'm pushing the limit a little more, with your permission of both of you, if you have time for the next about 15-20 minutes.
12:30 is a hard stop for something else. So maybe 12:25 you
okay.
can wrap up. We are good.
That's okay.
Yeah.
That's okay.
Another 15 minutes maybe.
Yeah. So my last question probably would be, Divij, till now, M&A was a simple act in terms of these kind of infrastructure takeovers. Now with things documented, those 100 questions documented in terms of the ESG policy, there is hardly a scope to cover up probably some infirmities, right? So how will that probably move ahead when in this new environment where a non-compliant asset probably been taken over by a very compliant company, something like that, and of course the ESG footprint?
So that has to be actually seen as to why. First of all, let's first understand why this is required. The reason why it is required is because, as we have mentioned, now it's an open market. We have a trade with, across the world, with Europe, with China, with the US. Now, Europeans are quite conservative in the sense they're really checking as to how compliant are you, because whatever said and done, India in its Paris Accord also has said that, we will be with this carbon compliance and net zero, all these things that India has promised. The intent is also to ensure 500 gigawatts of renewable energy by 2030, which is a tall task as well, but we are working towards it. There is a lot of focus on renewable energy as well. There are talks of carbon trading platforms and all these things as well. So why is there this need? One is to stay committed to what we have promised, and at the same time to ensure that we are not ostracized by these countries with which we intend to trade with. These requirements have been put into place.
Correct.
It has started off with the top 100 companies and then slowly expanding. The intent is to have more involvement. Now, it has started with a lower number to first test that, whether all these compliances are possible, because obviously there will be shortcomings. How do we tackle those shortcomings? What would be the effect of it? Will we be again having a backlog? all these things are going to be tested. And with that, there will be further solution. You never know. I hope there will not be a larger requirement. I hope the requirements can be sort of curtailed. Yes. Because the more the requirements you have, then that entire time is actually being spent in those compliances. We need something which is shorter, but at the same time, more, if not as effective, if not less, as in it has to be as effective as what its intent is supposed to be.
Got it. Sanjeev, you want to add anything, or we move on to the question and answers?
No, so the only thing is, with this increasing globalization, the world being, all connected, frankly, in a way without borders with regards to the trades and all that, and real-time impact in terms of the flow of information, both top down, bottoms up. I think it's a challenge as well as an opportunity for India. If we really, talk about our part of the world, that on one side you can learn quickly because rest of the world, especially, Europe, Germany, all those, places across Europe or to an extent US, wherever, they've already evolved to a certain extent. So you can pick up something and then tweak to the extent which is required for the Indian context. But the problem is, earlier we used to have an export house concept and then SEZs and all that. The rules and the regulations and everything used to be separate because they had to interact with those people one-on-one. So they said domestically alag rules, internationally alag rules. But environment is something where you can get inspired, pick up as much as you can. But in Indian context, you need to be practical. आपको अगर पेड़ कहीं नहीं काटना तो कुछ काम नहीं हो पाएगा. पेड़ तो हर जगह उगा हुआ है. Okay, but you need to have a good master plan, prevention wherever, and compensations and a proper policy and the rules and the SOP. And one thing very important, give solutions to the people when you want them to adhere law. आप ये कहोगे कि मैं आपको ये अलाउड नहीं है लॉ में, तो कह रहा है आपने कहा ये करना है, हाउ डू आई डू इट, हमें नहीं पता, लॉ में लिखा है नहीं कर सकते. If you can't park a car here, you can't park. The guy says, where do I park if I come to the market? The guy says, the answer is, I don't know. Now, this is wrong. And this can actually go to the macro level also, that you should have, and in policy making, our favorite statement is, a place for everything and everything in its place. It can sound, music to ears. It's impossible almost, but we should strive for it. अगर आप कुछ SOP बनाते हो, you have to think holistically. You are getting into development, environment is going to be impacted. If you again become myopic, environment को कुछ नहीं होना चाहिए, then forget about the development. At the end, you need to create a building. You need to mine the resources. आपको cement चाहिए, आपको steel चाहिए, तो iron ore चाहिए, तो you have to dig out. You can't create in a lab. Now, my point is, think holistically. ये होगा, तो how do you mitigate? So this is just the important point where every one of us needs to contribute.
Yeah. So guys, I'm going to hand over to Mukesh for the question and answers. There are a couple of them. Mukesh, over to you.
Right.
Mute.
If you're on mute.
Unmute, please.
Sorry. I mean, I know the session was getting more and more intriguing and interesting, so we really pushed the boundaries and the limit to go beyond the time. So we actually have some questions that have been asked. I'll quickly ask those questions. In fact, there are a couple of them I'll combine. One, it says that what are the industries impacted mostly, or they should be cognizant of environmental law? Is dealing with NGT enough, or there is more that one really should? And I'm combining with another one, is that how can companies avoid protracted litigation, or should mitigation planning be inbuilt in your daily operations? So I think merging them two. So Divij, I think you taking it forward from here. Yeah, please.
See, protracted litigation, you're absolutely right. There should be an SOP. There has to be a format that is followed, that what should be done before you enter into a litigation. So generally what companies follow is that, generally in commercial disputes, what we are seeing is that there is a two-step mechanism. That first is to escalate it to the higher management, then have a conciliation, attempt at conciliation, and in the event that is not possible, then to arbitrate. So yes, definitely something similar should be there, but in environment, the mediation is only possible once, I feel, if there is something formal, because so far whatever mediation that we are seeing in environment is once the matter has already reached court. And if the intent is for a speedy disposal and a speedy resolution to the problem, because more than disposal, it is the resolution that needs to be taken care of. Because so far, what if we have been discussing is that we are dealing with the environment here, and it is not something that, all right, if it may take 6 months or 10 months, or after 10 crores of compensation given, no restoration done, all is done. Because what we are also seeing is that let's just take the example of the Pacific countries. Because of the global warming, the rising sea levels, you can feel the desperation in how they are calling upon the developed nations to cut down on their emissions as well. And we may feel that this is a problem far from us, but it's actually closer to home. We also have coastal areas. Lakshadweep, recently there was a news article as well that Lakshadweep, the corals are going to be affected because of the global warming. So all these things need to be addressed, and we need to find a speedy resolution for it. And we need more responsible corporates, and we are seeing that as well. We are seeing responsibilities coming up in the corporates with their CSR reporting as well. So while it started off with a legislation, but we are seeing more companies getting into CSR. So yes, SOPs is a good start, and we need more formal policies towards speedy resolution in the form of mediation and then litigation, as Sanjeev also pointed out.
Right, perfect. I think extending this question further, there is, say that, what kind of success do we see in mediation, and how long does it really take? Sanjeev, I think mediation is something which is very close to your heart.
Yeah, I mean, I'll link it to the previous question as well, which was talking about the protracted litigation. So let me make a again statement in terms of we keep debating a lot on these programs and at the forum. So litigation can be a part of the strategy, right? But litigation cannot be the strategy itself.
Interesting. Okay.
Right? That's very important. And Divij definitely would appreciate that. We've seen people lad lenge, dekh lenge, as if this is the strategy itself. Wrong approach. Litigation definitely should be part of the strategy, because litigation per se is not a bad word. Litigation means adjudication. You have to go to the court, and people call it litigation. You are expecting a judge to interpret and apply the law, because there is a dispute which needs to be adjudicated. So litigation, from that context, just a part of the strategy, number one. Second thing is risk mitigation definitely has to be inbuilt in the SOPs, because we all live in a very dynamic world today. You can plan as much as you want. Nobody plans for 5 years now. We all understand, right? Because on the go, you have those, changes happening, and right, what hits you from where, I think it's very difficult. So one needs to plan. Now, there is this concept again, like, I borrow from our negotiation techniques, BATNA and VATNA. So best alternative to a negotiated agreement is BATNA. Worst alternative to a negotiated agreement is VATNA. Now, between these two, once you evaluate, then you say, nahi, ladna nahi, baat karte hain. And more likely than not, you would always say, chalo, baat karke dekh lete hain. But a lot of people are not aware of it. And if people are aware of the concept of mediation or negotiation in the right framework, then they are not sure about it. Confidence or experience, the first-hand experience, somewhere somebody needs to get started. This is important. Now, a private company, especially a private company, has to see the financial viability of every project, what they do. There is an answerability. There are funds which are involved, whether it's a debt or equity. There are people on their back, and they need to be answerable, accountable, which means you need to preempt, which means you need to mitigate the risk at every possible level, plan A, plan B, and all that. Now, jumping to the specific question about the mediation, look, it's evolving. We had Singapore Convention in 2019, and then COVID happened, and of course, things slightly got derailed to an extent. But commitment is shown by the government by bringing up an act of 2023, Mediation Act. It's yet to be notified, but it's a great step forward, right? So we've been signatory to the convention. There's a lot of buzz. People are getting trained by the day. And then, that 40-hour training, of course, 40-hour training does not make you a mediator, but it helps us to identify and discover a mediator. And then eventually it has to be a CPE concept where you continuously, add to your professional development and all that. So it's a great concept. It's a matter of time. It picks up, gets the steam, becomes mainstream, the way it has already become in US. Look, in US, they're talking about 70% cases going into mediation and about 80% getting resolved. That's an amazing number. Civil and commercial. Why can't we do that? Now, lok adalats are something which are coming closer. Settlements, right? These are settlements, but of course, a bit of challenges. The environment is, a lawyer or a judge sitting there. So there is that, it's per force kind of thing. You settle. So there is that inbuilt authority where it should be more calm. But the point is, it's happening. We just need to bring the court annex mediation even beyond the court annex centers. So it should be maybe a court-directed mediation. So even those cases come out. There are institutions, there are mediators who are doing the bit. So it's just going to pick up further from here. So it's a great area to be in. It can be a career choice for a lot of people. And frankly, you don't need to be a lawyer or a chartered accountant or anyone. Anyone and everyone can be a mediator. You just need to be impartial. But it's both art and a science. But the artist has a bigger role than the scientist. That's the only point I'll make. Yeah.
All right. Thank you. Thanks. And extending your question, Divij, to you actually, I'm just adding to this question further. Very specific question actually. They're saying, what are the risks for an NGOs working in a climate control initiatives or projects and all this stuff? The legal exposure. And continuing from what you were about to say, I'm so sorry. I just thought probably.
No worries. So the question is, I'm sorry, it's the risks that
NGOs working. So any legal exposure for the NGOs working in the domain of climate control, I think that's what they probably would want to ask. Mostly because of lack of awareness, they might not even know about certain things. So will they get number one? Will they get penalized if they don't know, or should there be a framework which they can really refer to or use? Sorry, I'm advocating the NGO right now. Probably I'm just preempting certain things, but that's how it is, I guess.
See, it's a very general question. In order to determine, what would be the penalties or what would be the risks, it has to be a lot more fact specific. For instance, if let's say it's an NGO which is into the upliftment of children, I don't see any. Yeah, I don't see any this thing. But if let's say it's an NGO which is looking into as environment as its theme, or
right,
the intent is with regard to that. So again, there is no risk per se for that NGO to be operating in that sphere. But yes, I don't want to discourage, because I've actually come across a lot of NGOs who are very thick-skinned, and they're very sure of what they want to do, and which is commendable. Despite the budget constraints and all that they face, they're very dedicated and very inspired by their cause.
Right.
And they're willing to in legal terms take whatever steps that they need to push for their cause, because of how committed they are to their cause. Now on that, I also wanted to discuss that question with regard to the timelines in mediation. So as rightly put by Sanjeev, don't look into the time that goes in there, but just to put it into perspectives, I want to just give a few examples across jurisdictions that we have seen.
Mm-hmm.
So one that I'm aware about was in the US, which pertains to the Great 8 Lakes, which cross through 8 districts in the United States. And there was, water sharing disputes and all these things were going on since 1927, protracted litigation. One would finish, then 10 years later, another would start. So they had actually gone through about 15 rounds of litigation over a period of 80 years. Then finally, those 8 states decided to get into a mediation, and believe it or not, within 8 months, they were able to come at a conclusion. And for the past 30 years, there has been no litigation.
Oh, Amazing.
This is one part. Another one I want to give something from our Indian jurisdiction as well. We had, although not environment related, I'm just on the point of mediation. We had a very highly contested litigation going on between, again, it was with regard to a particular project for about 15 years. The company spent a lot of money on litigation, and finally it went to the Supreme Court, and the first thing that the judge said was, you have been fighting for 15 years. Why don't you consider mediation? And at that point, we said, this mediation approach is what, between family disputes and all, and, how does it make sense here? Believe it or not, 15 years dispute finished in 3 months. So imagine if they had started off with that. Sometimes I feel in our context, it takes those 15 years to realize that what you could have done in 3 months, you have spent 15 years to finally do those 3 months.
Absolutely. Yes.
I think with time, so this is
fair enough. Lovely, Divij, this is a great example, and in fact, music to my ears by default. Now, with regards to the time, the only point is that, again, when we speak about time being time effective or something, this was more from the context of civil or commercial disputes, where till the time the parties are willing to explore an amicable settlement, they are still out of the court. Why put a pressure on timelines? So the Mediation Act says 120 and 60 days. I said, let them take 5 years. If both the parties are happy and it's a complicated, issue, and they're willing to, explore, they are out of the court. That's what you wanted in the first place, number one. But we had something similar in Kaveri disputes in India. Okay, every time the government change and you have this dispute coming up. So the beauty of the mediation as a concept is such, it's so flexible. If rightly understood, it's flexible like a amoeba. It can take any shape, size, a format, a face. It can fit itself to a context. So in regard to the environment, you don't have the luxury or the liberty of timelines. So parties, including the state and defaulter, possibly will have to be mindful of the timelines here, and the cost and the implications and the risk and the sustainability. So this is a given context. These are the given constraints within which they have to do mediation. But mediation still works because it's a dialogue first. You're not adversarial. We're not saying tum galat, hum kehte hain galat, because I keep saying unintended consequences have to be treated. You can't shoot the people all the time. हो गया, एक पेड़ नहीं कटना था, कट गया, ऐसा होना नहीं चाहिए था, हो गया. Okay, you want to shoot him? Is that the answer? No. Common ground. So a cost penalty will be a deterrent for sure. Okay, some kind of a sanctions going forward is a great deterrent. आज के बाद हम आपको ये नहीं देंगे, you are blacklisted 5 years. That's a big deterrent. But all this can come as part of the discussion. You've done something, you need to repay. You need to compensate. Okay, you spell out. Let the other party, the aggrieved party, also spell out. Somebody in between says, okay, this looks, but you use the, there you go. 3 minutes. Next thing, I'll have to really, move out. But great, Mukesh. Thanks, Divij. And
one quick comment. I mean, Joyce wanted to simply thank both of you specifically. He said that it's been a great session, and in fact, I also echo his points of view from mediation. He said, you very rightly mentioned by Sanjeev, saying that all the scope 1, 2, and 3 itself will, how will it be feasible to put all of them in one report? And I love Divij's point of view about, not just Joyce, me too, is this about the fact that it's always good to have those laws in place to and make mistakes rather than having nothing at all and learn from it. I think it's a great thing. Any resources, like Joyce wants to know, any resources where they can study further on environmental law, the kind of something that he can refer to and figure out, so that I think he's conducting some research right now. So any place where there could be some references to read through from an environmental law in a quick 1 minute before you leave, and that's probably the last question for the day. Yeah. Any of you can take it. Yeah.
It depends on how in depth you want to go, because there is so much of resource. It's unbelievable.
Assuming it's starting
across jurisdictions. I would say that there is a very good library across the Supreme Court. Start from there.
Sure. I think that'd be a great starting point. and great, comment to end with today. Thank you very much, both of you. It's been such an amazing session. We've already extended it by half an hour, and I think that is still not enough. We should probably have you two again on another session soon enough. So thank you very, very much from everybody who's been sticking around, and I see that attendees have stuck around right through the session. So, I did not even see any attrition happening. The people who joined in, they've really stuck around, all of them practically. So
thank you so much for having us, and it's been a pleasure, interacting and learning from two stalwarts as well.
Thank you.
And I'm enjoying the company of lawyers. Is a change, as you likely said.
I will
Be
make
happy
it
to hear
small
that.
with a gap and then a what.
all through the discussion, I never behaved like or spoken like a lawyer. So discount me on that.
नहीं वो तो आप
That's
क्योंकि
the
पहले
degree with
ये
me.
होता है कि आप LLB नहीं बने ना.
Different advocacy. Yeah, it's a different advocacy altogether. Right.
Chalo,
Thank
great
you.
then. I'll make a move. Thank you.
Thank
Okay.
Thank you so much.
Bye.
Thank you so much, everyone. Thank you. Bye-bye.
Thank you. Thank you.